The Maritime Labor Convention is really an important convention to me, and I hope it will be for you. How many of you are intimately familiar with the Maritime Labor Convention, what it is, how it came about? Okay, so I think it's important to kind of go through what the convention is, how it got where it is, where it's been, and where I think it's going in the future. Is that okay? So for me, I think, I've often said this, you know, if anybody who's heard me lecture, I love to talk about history. And you talk about the history of maritime law. It's an ancient law that developed, you know, thousands of years ago. I mean, the first, you know, written code that contained maritime law was in the Code of Hammurabi, like in 1750 BC. So it goes way back. But most of the laws that we deal with today come out of the 13th and 14th century codes. The maritime law developing to protect seafarers has been developing over a long time. But the most significant single achievement has been the development and creation of the Maritime Labor Convention. What does it do? It sets minimum standards for working on ships. It does this by consolidating over 60, 70 different ILO instruments into one consolidated document. 100 pages of easy reading English language. And it's translated into French too for the Canadians. Establish conditions of employment, and you know, it promotes compliance through flexible implementation. By that we mean, and we'll get more into this, that countries can have their own rules that are substantially equivalent. So you can't just look at the convention and read the convention as if it's the law, because the law is the country's implementation through its substantial compliance. Now, the morning session, there was a lot of discussion about this because there's some concern that there's no uniformity. But it is a double-edged sword. You know, if you have it too uniform, then it may be difficult for some countries to ratify it. For example, in the United States of America, one of the big things holding up the ratification is a definition of a vessel. Some of the offshore drilling rigs, which would be considered a vessel under the MLC, but creates a difficulty for the offshore oil exploration industry. And it has strengthened enforcement. There are robust enforcement mechanisms within the Maritime Labor Convention. But I think it goes beyond that. One other point I should make, though, when you read about the history of maritime law protecting seafarers, you see that it developed out of ship owners' best interests. And there's a real interest for ship owners to have this law protecting seafarers because, you know, if you want to protect your business, you got to be able to get good and responsible people and keep them. And what this law does, this convention does, is it does that. But I also think it addresses, in that regard, it addresses maritime security. How does it, has anybody seen the provision of security in here? Those of you who are intimately knowledgeable about it? It doesn't say anything about security, but that's because a lot of people don't realize that the biggest threat to maritime security isn't coming from terrorists. The biggest threat to maritime security is getting enough good people to operate vessels reliably and safely. And with this, it strengthens security by encouraging good, responsible people for taking on careers in shipping, seagoing careers. It's very similar to ILO 147. For those of you who have used ILO 147, it promotes maritime safety, and it helps reduce casualties. The biggest cause of maritime casualties are actually not caused by ships. Ships are actually pretty safe machines. It's the people that are dangerous. People are dangerous and unpredictable, and they get tired, they make mistakes. If you don't feed them right, sometimes their stomachs get upset and they do things they shouldn't be doing. What the Maritime Labor Convention does, it helps promote safety by looking at the human factors of maritime safety. And I put on environmental protection too. We're very interested in environmental protection, but I remember a case we had in the Port of New York not well, a few years ago, where a ship came in, the crew was from Brazil, they're walking around in their Havaiana flip-flops and shorts, and it was in the middle of January, and they're freezing to death, and they're getting under like a incandescent light bulb to keep warm. And one of the engineers was going down, pumping oil or something from one tank to the other, made a little mistake, and instead of pumping it to another tank, he pumped it over the side, which created a little bit of a problem for the ship. But that was caused by fatigue, being cold, just making a human error that we all do if we're in some similar circumstances. Well, let's talk a little bit about how it came to be. Back in 2001, the ITF and the ISF, the unions, the trade unions, and the ship owners organizations got together and decided we should make a convention dealing with labor conditions on ships that would be equivalent to the major other conventions. The other major conventions would be SOLA, Safety of Life at Sea Convention for ship safety, coming out of the Titanic, and the STCW, the training and qualification requirements for seafarers, and MARPOL, which everybody in Fort Lauderdale knows everything about MARPOL, right? The oil pollution regulations. So those, yeah. So those are the and also up in New Hampshire, they know about that there too. But so they wanted the labor standards to be the equivalent of those other three major conventions, which most maritime nations have ratified. And why did they come together? Because the ILO works on a tripartite structure, meaning that you go to the ILO building, and you look in the building and you see the ship or the government sitting in the middle. And on the left side are guess who? The unions. And on the right side are the ship owners. But all the decisions are made basically by consensus or agreement between all three groups. So no one group can really decide. And usually what has happened in the past is these meetings at the ILO were kind of like a labor negotiation, where the unions and ship owners are squabbling with each other, and the ship owners or the governments could just, sit down and wait for the dust to clear, knowing that nobody could ever get an agreement, so it'd all go away. Well, the problem here was that in 2001, with the ship owners and the unions agreeing to go forward with this major convention, that the governments had to sit up and take notice. And they did, and they got very involved. And that's through a 5-year process with 85 different countries participating, they produced the Maritime Labor Convention. And I will say 2 of the really major voices in the room were the Canadian government and the US government. There were others too, but the Canadians and the Americans were very heavily involved, particularly the Canadians. So something you should take a lot of pride in, because not only were the Canadians very involved, but they're very involved in listening to the one particular non-governmental organization, the International Christian Maritime Association. So the chaplains actually worked very collaboratively with those 2, and other countries, Bahamas and others were very, very helpful. I want to take one moment just to bring up kind of a sad note. The government spokesperson was a German lawyer named Dirk Lindemann, who was very, very willing to listen to the ICMA poor chaplain's concerns. And in fact, he was singularly responsible for ensuring that the ILO 163, the Seafarers Welfare Convention materials, got included into the Maritime Labor Convention. Dirk died yesterday, so we're very sorry to hear about that. If you could include him and his family in your prayers, I would appreciate that, because you'll probably remember, those of you who went to the ICMA conference in Germany, he spoke there as well. Okay, well, so this, in 2006, took 5 years' work, the International Labor Organization put together this massive convention. And it was really difficult because you had, several different conventions that had different definitions, different requirements. So you could, who is a seafarer? Can you tell me who a seafarer is? Well, you'd think it'd be pretty simple, but actually it was a very contentious discussion. Who is a seafarer? because a lot of the requirements for the convention would depend upon who is a seafarer. You know, is a hairdresser on a cruise ship a seafarer? What do you think? No? How about like a musician on a cruise ship? You're saying no. And you've seen the movie Titanic. And as the Titanic is sinking beneath the icy Atlantic waters with the band playing Near My God to Thee, and you're saying they were not seafarers. Ah. Well, of course, there's a very broad definition, and they are seafarers. But the biggest controversy wasn't about the hairdressers or the band members. It was about whether a master is a seafarer. And that was a big controversy because is a master going to be limited by the hours of work and hours of rest requirements? So a master is. But anyway, it took 5 years to put that together, and then for the convention to come into force. And in fact, it was adopted in February 2006. That's why it's the Maritime Labor Convention 2006, without any dissenting vote. There were 2 countries who abstained, but that was just on technical reasons. They were not opposed to the convention at all. So it was extremely unusual that such unanimity in the ILO amongst countries to adopt this major convention. But the convention required that you had to have at least 30 countries ratifying the convention, representing a third of the world's fleets. Well, that was finally reached in last August, 2013. So it took a few years for the 30 countries to reach that threshold. And it comes into force for those countries that ratify it 1 year after they ratify. So even though now it is in force as of last August, it's only in force in those countries which had ratified the convention by last August. At this moment, there are now 56 countries that have ratified the convention, representing 81% of the world's shipping tonnage. So by and large, most of the ships that you're visiting as chaplains is probably in a country that has ratified the convention. And as we learn a little later, that'll be important to you whether or not your country is among those that have ratified it. Okay, so here are the, actually 31 countries where it was in force as of August last year. So those are the countries where it's in force as of the 31st of August. And you're not going to remember this, but you see next August 7th, it's going to come in force for the Brits, for the United Kingdom. Whether that will include Scotland then or not, I'm not sure, but maybe you can tell me. But anyway, what's a growing list? But who's missing? China. But importantly for this group, USA. USA has not yet ratified the convention. And we've been pushing the USA to ratify it. I can tell you at least the status right now is that unlike many, many other countries in the world, the United States will not ratify a convention until all of its internal regulations are in compliance with the convention. The United Kingdom, on the other hand, has ratified the convention, is now trying to get their regulations in conformity with the convention. And they're actually quite a ways off to make that happen. Canada started working on their regulations, and they had their regulations in conformity before they ratified it. So Canada's really one of the countries that was really ahead of the game. Now we're getting to the exciting stuff. You know, like how the Bible's set up with chapters and verses and things? Now I want to tell you how the MLC is set up. Are you ready for this? Okay. There we go. This is great. I mean, but what you need to know about that is you have articles, which are broad statements, kind of like, you might say, like a constitution. And then you have underneath regulations, which are mandatory requirements. And under regulate, they're kind of like maybe statutes sort of like that. If you look in that sort of U.S. legal structure, standards are, you have standards and guidelines. These are kind of like regulations, but only standards. So if you see a letter A in front of a standard, that means it's required. That means it's mandatory. If you see a B, that's a guideline. That's guidance that the ILO has given through the Maritime Labor Convention on implementation of the convention. So if you got something that has a B in front of it, it's not mandatory. It's only guidance. So, I mean, if you look, do you all have your copy of the MLC in front of you? You didn't? Okay, well. So what's in the Maritime Labor Convention? Well, there are minimum standards for working on a ship, conditions of employment, accommodation, health protection, also in Title IV, welfare, we'll get to a little bit of that. But this is kind of the basic stuff, what's in the Maritime Labor Convention. The requirements to work on a ship. Well, there's a minimum age. You know, we can't hire babies anymore, or little kids. You know, you got to be at least 16. ICMA, by the way, when we were there, we're saying got to be at least 18, but we didn't win out on that. Requirements for a medical certificate. You got to have a medical certificate every 2 years. What's the U.S.? That's another area where the U.S. has to change its rule because the U.S. is more than 2 years. Was it 5 years or 3 years? 5 years, right? So we'll be changing that to 2 years. The requirements for training and qualification. By and large, the training and qualification requirements are going to the STCW. But there's a couple jobs that in the STCW that are not covered, like, for example, an AB. There's no requirements for an AB in the STCW or for a ship's cook. So there's added requirements here. Eventually, they hope that to go into the STCW, Standards of Training and Certification of Watchkeepers. And then recruiting and placement. I want to make a point about that because the major enforcers of the Maritime Labor Convention will be flag states, port states, and because there are regulations, requirements for recruiting and placement agencies, labor supplying countries also have a role in this. So it's very important that labor supplying countries ratify the convention. And I'll get to a good reason for that later. I think the American trade unions with their hiring halls are considered placement agencies. So
legally, I don't know that. No.
Yeah, but it could be under the convention. So
that's what I'm thinking when you're saying it.
Yeah, but that will be something that will have to be worked out with the U.S. specific regulations. And if you just read the convention, you would have to conclude that as the convention is written, U.S. hiring halls would be placement agencies. But there again, the U.S. could deal with that in its own way.
And it goes back to what you were even saying before about definition.
Exactly.
What, you know.
Yeah. How do we define that in the U.S.? And do you have to, for example, there's a prohibition against charging a seafarer a fee. And is
The union dues a fee.
Is that, yeah. So these are some of the questions we have to resolve. Okay, conditions of employment. This is really employment. Now there are requirements for having a contract, a signed contract for each seafarer. And what's in that contract is there's a list of things that are in the must be in every contract. And this is something that has to be inspected. And the seafarers have to have a copy of it. A lot of times, you've seen the POEA contracts, it's like a one-pager that refers to a bigger contract, or even some of the ITF contracts will say, this refers to the collective bargaining agreement. Well, they also have to have a copy of that collective bargaining agreement. You just can't have that one-pager. Hours of work and hours of rest is now in conformity with the STCW. The Standards of Training and Certification of Watchkeepers have hours of work and hours of rest requirements, but originally that was only for watchkeepers. Now it's for everybody, and the requirements here for Maritime Labor Convention are for everybody working on a ship, including the master. Entitlement to leave, basically get 30 days vacation a year. You can't have you have to have one vacation a year, so that means you can't have somebody work more than 1 year without a break on a ship. Other thing, going back to wages, there's no minimum wage in the Maritime Labor Convention. That's really kind of left between negotiating between unions and ship owners, or between the ship owner if an individual contract with the owner. But for our benefits, though, there's a requirement. You know, as port chaplains, we often see situations where seafarers haven't been paid for a couple of months. The MLC requires they be paid every month. Paid every month. And all these other things are, I don't want to spend a lot of time with it, but there's basically the standard requirements. The ship owner has to pay for repatriation. You know, if the ship sinks, you got to have some compensation. And manning levels kind of goes to the IMO regulations on safe manning certificates. And there's requirements for countries, particularly labor-supplying countries, to have programs in place to educate trade and seafarers. Title III, the accommodation recreation facilities is pretty much a naval architecture exercise. You know, you measure the size of the stateroom, how many toilets are there, and do you have a window? Can you and that's really kind of like the ship design. It's kind of hard for us to get involved in there unless, for example, if the toilets aren't working, that's an issue. But food and catering it goes beyond the ILO 147 requirements. Recall in our training in the past that ILO 147 requires that food must be sufficient in terms of quantity, quality, nutritive value, and variety. Well, the MLC goes a little bit beyond that and says you should also take into account cultural and religious considerations. It's still kind of vague in some regards, but this is an area where chaplains can really help remove the vagueness by helping port state control define.
And are these mandatory provisions?
Yes. Yes. These are mandatory provisions. Food has to be sufficient in terms of looking at the vessel's voyage, sufficient for the voyage in terms of nutritive value, quantity, quality, quantity, variety, cultural and religious considerations. Health protection, medical care, welfare. Well, basically the requirements for health care are pretty much the requirements of law that's been in place since the 13th and 14th century codes. The ship owner's got to pay for medical care, plain and simple, for anything. But access to, this is an area that we really are concerned to all of us, is that there are requirements in the MLC which are not part of the enforcement provisions, that basically port states who have ratified the MLC are kind of responsible for ensuring that where welfare facilities exist, that they're available to seafarers irrespective of their race, religion, flag, or nationality. Basically, you can't exclude some seafarers. But it also sets up a system for port welfare boards, regional and others. It's really a system to get the ship owners, the unions, and the governments involved in promoting welfare in the ports. The convention, however, does not include the welfare providers themselves being part of that process. But it encourages, because in most parts of the world, seafarers' welfare, shore-based seafarers' welfare, is provided by voluntary Christian organizations. But because we're not part of that tripartite system, it's kind of difficult in North America for this aspect to be implemented, I think, in the way that it was intended, because the unions and the governments and the ship owners actually have no control over our independent organizations. We have a NAMA board. Most member organizations of NAMA have their own board. they're not subject to whatever NAMA says, nor are they subject to, say, since they're not getting any money from the government, they're not subject to government control. So, but it's still something to encourage. There are welfare boards in a lot of ports. Even in the United States, I don't know about in Canada, but there are welfare boards and they're to be encouraged, even if they're not exactly like what's defined in the Maritime Labor Convention. But the important thing is that there's no obligation in the MLC for governments to pay for it. In Part B, it gives some recommendations on how they can support, like port levies, for example, but that's in Part B, right? Isn't that what you talked about yesterday? So this is an important area for real development. I think ICE1 is doing a lot in this area, and NAMA, I think, NAMA actually did the first survey of port levies some years ago in the United States and Canada. Anyway, that's important thing though. It's not included in Title V enforcement. But that doesn't mean it's not as important as every other part. Just because it's not part of Title V enforcement doesn't mean that it's not important. And it's not as, it's as important as any other part. Okay. Are you ready? Okay. So how is it enforced? What makes the Maritime Labor Convention a little different? Well, the main thing that makes it different is that flag states have to issue a certificate showing that a ship is in compliance with the Maritime Labor Convention. Now, the convention basically covers all vessels in international trade. But vessels of 500 gross tons or over have to be inspected by the flag state for compliance with the convention. And these results of that inspection is called a Maritime Labor Certificate. And that certificate is issued by the flag state, but it includes the Declaration of Maritime Labor Compliance, which has two parts. Part 2 is prepared by the ship owner, and that shows how the ship owner is complying with the convention. For example, the ship owner has to verify that it's only using placement agencies that comply with the convention, even though they may, for example, you didn't see Ukraine on the list of countries that ratified it, but Ukraine provides a lot of seafarers through their manning agencies. And the Ukrainian manning agencies historically have collected fees from seafarers for a job, prohibited under the Maritime Labor Convention. So it would seem to me that a ship owner must include in their DMLC Part 2 that they've checked out their Ukraine, I'll just use Ukraine as an example, it's not the only country like that, that Ukraine, their manning agency, placement agency doesn't charge fees. But we know they are. But anyway, then the flag state has to prepare DMLC Part 1. Why is that important? It goes back to substantial equivalence. The flag state must put in its DMLC Part 1 an explanation of its internal regulations that might be somewhat different. In other words, those areas where they're using substantial compliance instead of the words and verse of the convention. So that'll be important for investigation or inspections by other countries. So DMLC Part 1, the flag state explains their laws to other countries. And DMLC Part 2 is prepared by the ship owner explaining how it is in compliance, that it has the procedures in place. For example, they'll inspect whether they have contracts, and their contracts are prepared. And after all that is done, then the flag state will issue a Maritime Labor Certificate. This is a very important document because this document says to port states, who we'll get to later, that the ship is in compliance and it's prima facie evidence of compliance. And port state control cannot go beyond that certificate unless it has some reason to do so. Inspections, the Maritime Labor Certificate is good for 5 years, and there must be an interim inspection during that 5-year period. So basically, there'll be like an inspection after 3 years, or 2 or 3 years. So there'll be 2 inspections within that 5-year period.
Being done by whom?
By the flag state.
So if it was United States, in most cases, it would be Coast Guard.
It would be the Coast Guard, but they can also have recognized organizations do that. A recognized organization is a classification society. So the Coast Guard could have ABS, Lloyd's, DNV do it. Yeah, but do the inspections, but it's the U.S. Coast Guard that would issue the certificate. Okay? Onboard complaint procedure. There has to be an onboard complaint procedure where it's explained where the seafarer can have, if he has there's a deficiency of the MLC, there must be a procedure to remedy that on the shipboard and up to the flag state. And the seafarers have to be informed of that, they're supposed to be trained of that, and this is one of the real shortcomings so far, but it's in there. And it's an area where we all have to work, I think, to help educate seafarers of their really powerful rights and obligations, actually, to see that the MLC is enforced and that the deficiencies are corrected. They're afraid to now. And there also has to be a procedure for investigating marine casualties, but it's okay. We're running short of time, so I want to go quicker here, but okay, I already talked about this, right? And the complaints are confidential. They have to be kept confidential. That's important. But also, any person with an interest in the safety and welfare of a ship and its crew can bring a complaint. It's not clear, and who would that be?
Team chaplain.
But the way Part 5 for for flag state, it doesn't have that same confidentiality requirement for other complaints it has for seafarers. But I think flag states would generally keep that confidential. They would certainly, when I have taken complaints to flag states, they've been more than bending over backwards to, I don't care if they tell it came from me, but they want to protect the seafarer. Okay, basically, it's there. Read it and take it. But basically, we're running out of time, so I want to go a little quicker. Now, this is what you're asking about?
Yeah.
Port states may inspect foreign vessels coming in their ports for compliance. It's not mandatory that they inspect every vessel, but they can inspect vessels. And essentially, port state would, for you Canadians, that would be Transport Canada, would do a port state control inspection to look at a ship to see if it has a maritime labor certificate. If they have a maritime labor certificate, inspection would stop there. Unless, for example, port chaplain, talking to the crew, discovered that the crew hasn't been paid for a month and a half. Bring that to port state control, they can go beyond the maritime labor certificate and look at that particular, to see if the crew's been paid properly, or whatever. Port chaplains can bring any deficiency. That's why it's really, really important for chaplains to have a good working relationship with port state control. Because they can, and the other thing is that port state control doesn't have the resources to inspect every vessel. They want to use their port state control officers most effectively. So they actually appreciate having the insights from a port chaplain on steering them where they ought to be inspecting. Yes?
We've got a real issue with that, Doug. We've been told by our captain of the port that until the United States of America ratifies, they will not respond to MCL complaints. they'll respond to
Right.
seafarers' rights complaints that have been very supportive
Yeah.
of our chaplains, but not if we try to play the MLC card.
That is absolutely correct. The U.S. hasn't ratified it, so the U.S. is not in position to inspect maritime labor certificates or compliance with the, but let's wait, hold that thought though. And I'm talking to the Canadians. And, you know, maybe next year to the Americans.
You can still contact the flag state.
Absolutely.
They have a
That's,
certificate.
that's,
We
it's,
call Doug, he calls the flag state.
yeah, well, either, whatever, but either way, the important thing here is for Americans to understand the convention. That's why I went so much into the flag state responsibilities, because we can still contact the flag state. And probably, if it is a deficiency that we're dealing with, it's probably in ILO 147 that the U.S. Coast Guard can act upon. You know, if it's dealing with food accommodations or something like that. Where was I here? So it gets kind of complicated, you know, what happens, but I think it's enough for us to know right now that the port states have a very important role in ensuring that the Maritime Labor Convention is implemented. But what happens if a ship comes into a port, Canada, ship comes to Canada from a country that hasn't ratified the convention? Country that hasn't ratified the convention, they will not have a maritime labor certificate, will they? Because they can't. You can only issue a maritime labor certificate if you're from a country that has ratified the convention. Well, fortunately, the Maritime Labor Convention has a procedure of no more favorable treatment. What that means is you can't treat non-ratifying nation ships more favorably than ratifying nation ships. So there's a requirement that, let's say in Canada, that all ships coming into port must comply with the Maritime Labor Convention so they can do a full inspection to ensure compliance. And how long is that going to take? A long time. I think there's been a lot of progress. I think when you look at how the flag states have been implementing it, they've really done a pretty good job. Is it perfect yet? Absolutely not. But we've gone a long way. And I think with the help of port chaplains, particularly in the U.S. and Canada, there's going to be an agreement between U.S. and Canada on how to deal with American ships if it's not already agreed to. The U.S. has put out an instruction on voluntary compliance, where U.S. flagships can be inspected and get a certificate that's kind of like an ML, Maritime Labor Certificate. So at least if they do get inspected by those Canadians, the ships will get through the inspection pretty quickly. Or the Brits next year sometime. Okay, listen, we have to get out of this room now, but if you have any questions at any time, please don't hesitate to contact me. What we heard today was that seafarers don't know about the convention. Someone suggested chaplains don't know. Chaplains do know. Chaplains received a lot of training, and they're going to get more. So we have a very, very, very important role in not only the effective implementation and enforcement of the convention, but also in implementing the seafarers' welfare provisions of the convention.